SJC-11221, Commonwealth versus Eric Durand.
Good morning, Your Honor.
Good morning.
May it please the Court, Gary Pelletier for Eric Durand. With me at counsel table is Attorney Timothy Bradle, who is also trial counsel as well. Your Honor, there are several issues that I'd like to address if I can get to them, but with the Court's permission, I'll start with the Confrontation Clause violation that occurred here. That there was an email that was the subject of, that led to the termination of Dr. Abram Phillips, who was the medical examiner in this case. And that email, Judge Kane forbid cross-examination on that email itself and on the termination of the medical examiner from the OCME. We would argue that that was a Sixth Amendment Confrontation Clause violation because it cut off essential cross-examination.
What would that cross-examination have shown? Because the judge did carve out whole areas where the counsel could and did cross-examine this person, and you say it goes to judgment?
I would say it goes to
How? I'm having trouble understanding that.
So the cross-examination as to that issue that the judge was willing to put forward was very limited. It was just on whether the file whether he was rushed in performing his autopsy or whether that file being locked away may have interfered with his ability to do an autopsy. What we're talking about here is the actual termination from the OCME, and the fact that in writing this email, he exercises very poor judgment in terms that winds up getting him fired. And the fact he's being fired, the fact he's using poor judgment is something that's essential that we would have a right to cross-examine on.
Well, poor judgment and poor judgment. I mean, poor judgment in your personal life doesn't equate with poor judgment in your professional life.
Well,
two different things.
But we're not talking about an extramarital affair or something as personal.
No, we're talking about an email that is, I don't know how you would describe it. I read the email, but I mean, I don't know how you get from there to poor judgment in the email to this affecting the accuracy or validity of the autopsy. That's what I don't get.
Well, it goes to the fact of he writes this email which talks about certain things regarding the charts and talks about how the charts being locked away because these allegations, and that leads to his termination, him writing that email. He indicated that it was in connection that he believed was some sort of retaliation for some earlier misdeed with a contamination of a death certificate. And so the fact is that here he has engaged in this activity that winds up being terminated for, and it all comes down to simply he's terminated by the OCME. He's terminated for lack of professionalism, lack of judgment. It's not something in his personal life. It's something in his professional life that he's engaging in by being unprofessional and writing this type of email. The fact he's terminated for this unprofessionalism is something that we should have the right to cross-examine him on. In any other context, I believe we would have that right.
But the judge allowed you to cross-examine him as to his unprofessionalism with regard to this particular case, right?
No, the judge limited the cross-examination. The judge limited it to the two questions, essentially. Did he feel rushed with this autopsy? And was there any deficiencies in terms of memory because of the time that it took to write this autopsy? It wasn't. He specifically forbid us from going into anything as far as his lack of professionalism or anything surrounding his termination from the OCME. Not only couldn't we get into this email, and I can understand possibly if he said, we're not going to allow you to introduce the email, but you can question him on aspects from it, or you can ask him about his termination from the OCME, but he forbid us from doing that, forbid us from going into the lack of professionalism. And I mean, the whole thing is, the United States Supreme Court has held in a couple of cases. I mean, Melendez-Diaz, obviously the court's familiar with it, where its cross-examination is not only an opportunity to expose the fraudulent analyst, but the incompetent one. And in Melendez-Diaz, they specifically mention allowing somebody to go into a deficiency in judgment, which is what we would have here. Bullcoming versus New Mexico, also a case where, in that particular case, this person was terminated from, or placed on administrative leave, I believe, from the New Mexico equivalent of the OCME. And they didn't even know the reason, but the United States Supreme Court said you'd be entitled to go into that, go into exactly why this person was terminated, because that all plays into this. We had a situation here where Mr. Bradel brought out the fact that this particular medical examiner mixed up fingerprint dye and didn't even know that. Those are all questions that we go to. His lack of competence, his lack of professionalism, he's terminated for the actions he takes, the unprofessional actions he takes.
Well, we don't really know very much about why he was terminated, do we?
Well, I mean, there's an opinion on that from the First Circuit. And
he succeeded before the First Circuit?
no, he lost in front of the First. There were two, there was a Suffolk Superior Court case and a First Circuit case. In the First Circuit case, it was a trial, and the trial judge granted a motion to the civil equivalent of a motion for basically found for the defendant and for the OCME, and made a determination that that nobody could, no reasonable jury could actually find in Dr. Phillips' favor in that case. So he lost that particular case. And there were two grounds that they viewed for his termination. And they explicitly set those out in detail in that court's opinion. And they talk about the first one was a contamination, a contaminated death certificate, and his incompetence with that. That was part of it. And the second one was the writing of this email. And he said in connection to that, he believed it was retaliation, that they were taking actions to retaliate against him or connecting him with some sort of punishment for this contaminated death certificate. So they go in very, very detail in that opinion as to reasons for his termination. And when Mr. Bradel brought that up during trial, said, I can prove this up, Your Honor, in his offer of proof, and it show exactly what happened. The Suffolk Superior Court case, he wound up prevailing on that.
Okay,
So,
but, I mean, trial court judge sitting there worried that this is going to be a whole detour into 2 or 3 litigations concerning the termination of Dr. Phillip, and the judge is saying, you know, the issue basically is what was the cause of death of this young child, and aren't we going a little bit far afield, and can a judge exercise a discretion in that regard?
I think if it were far afield, maybe, but this isn't going, the judge can certainly put parameters on this and say, I'll allow you I'll allow you briefly to get into this, but I mean, to cut off a question when a person is terminated for a lack of professionalism or a lack of judgment and not allow at least some level of cross-examination on that, I submit that that's a violation of Mr. Durand's Sixth Amendment rights. And again, I point out Bullcoming versus New Mexico, not to belabor that point, but that is the situation where, in that case, they didn't even know the basis. They know he was terminated, but didn't know the basis. They said, you're allowed to get into that. I mean, it's just basic cross-examination that you're allowed to do. It's a Sixth Amendment right. I mean, this court has recognized that Penn versus Ritchie, the United States Supreme Court, you're given wide latitude in this situation, and I think with Melendez-Diaz and Bullcoming, they've reinforced that.
Well, Bullcoming didn't have all of that in front of them. They didn't have a trial judge's ruling that this area could be explored. In other words, it wasn't granular. It was sort of more hypothetical about why you'd want to witness there, not we would rule that question A and question B were improperly excluded. You know what I mean?
It didn't go into that level of detail, but the United States Supreme Court said had this been presented, had this witness been there, the defense counsel could have gone into the reasons for his termination.
Assuming that the trial judge would rule that that wasn't a complete distraction from the underlying.
I don't think the United States Supreme Court said anything. I think anytime somebody.
One thing to say, you can call witnesses. Witnesses should appear because you can go into bias, prejudice, and everything else. And very different when you actually have a witness on the stand and the judge has to evaluate whether this line of questioning opens up a completely irrelevant subject matter. I mean, that's just a completely different call.
I just don't see this as an irrelevant subject matter when you're talking about somebody being terminated for a lack of professionalism or a lack of judgment. When you're applying, judgment is something, it's not just a judgment in somebody's personal life, it's a judgment call that he makes as a professional decision in writing this particular email, and how he potentially embarrasses the office. Again,
He was not just terminated for this email, though. He was terminated, you said, for another reason.
Two
which had to
reasons,
do
Your Honor,
with
yes.
the screwing up a death certificate.
that's correct, 2 reasons, Your Honor. But I mean,
So if the judge had said, you can get into the basic reasons, but no more, I don't want to have this turn into a circus about, who was right and wrong about the termination.
I would think that would be proper. I would think he could limit the cross-examination to the reasons for his termination, his lack of judgment, his lack of professionalism, without going into 2 litigations or stuff that happened before the First Circuit or the Suffolk Superior Court and getting completely sidetracked.
Was there a cross-examination, though, that went to issues of his competence or judgment? You said about the mistaken...
The mistaken, yes, the mistaken die, that was something that did go to his competence and judgment. I would submit that did. And that was something that we brought out to show that he wasn't particularly competent. I think that, again, we're talking about something here that was a battle of experts. There wasn't a lot of evidence tying Mr. Durand to this particular crime, so we're talking about a battle of the experts. And when you're talking about that type of situation, then what you need to do in that type of situation, anything that reinforces that he has a lack of professionalism or judgment, I think is essential to the cross-examination. And that should not have been wholly extinguished, to not allow us to get into something as monumental as having somebody as a termination, and the email that led to that termination.
Was this the linchpin of the Commonwealth's case, the autopsy report? How important was it to impeach the competence of Dr. Phillip?
That was the Commonwealth's case, I would submit. I mean, this is a case where there were no eyewitnesses. It was a circumstantial case. There was a ruptured duodenum. There was nobody that actually saw anything. There was Mr. Durand's statements to the police, but he expressly denied doing anything to the child. And there's a question of, okay, how did this person die? And what exactly caused his death? And that was the question.
So was part of the defense in the case that the child did not die by a blow to the stomach, which I guess was what the autopsy report said caused the injury that caused the death?
Right, there have been a couple of theories that were advanced by the Commonwealth. In their previous case, they were saying it was a squeeze.
No, I mean, what was the defense's rebuttal to the Commonwealth's claim that this is the cause of the death?
The defense, through Dr. Stan Kessler, the late Dr. Stan Kessler, brought up that the death was consistent with the jumping of a cannonball from his 4-year-old twin brother, a roughhousing sort of cannonball type situation, and that may have been what actually caused the death, as opposed to a punch or a blow that would have severed it. Does that answer your question?
Yes, thank you.
I'd like to, unless there's any further question on that issue, turn to one of the other issues in the brief, and like to get into skipping into the third issue that I raised, which is there's a question of here. There was an inadmissible statement that came in during the course of the trial, and that particular statement was a statement made by, or there was prior. The judge asked the parties to go through and edit, consistent with a motion in limine, edit some information that was going to come in. When the information came in, the jury heard something that Judge Kane had previously ruled inadmissible.
Well, whose fault was that? I mean, didn't the judge give defense counsel an opportunity they took a day off to do the, why did that happen? Why wasn't defense counsel in a position to make sure that the redactions had been appropriately done?
Defense counsel did, and the understanding was that information, the parties went through that. The understanding was that information had or would be redacted. There was an agreement as to what exactly would be redacted. And on that particular day, the Commonwealth plays the video, and that information that was supposed to be redacted, that the Commonwealth had pledged would be redacted, comes out, and that's out there with a statement that about pushing Michael, and it's a long statement. So it's a fair.
Was that the result of prosecutorial misconduct? I mean, was the defendant taking the position that the Commonwealth had intentionally not redacted as it was directed to do, or was it negligence? What was the explanation?
I don't know. I mean, obviously, it's if it were a prosecutorial misconduct, it would be even more of a linchpin in this case. I don't think you need to find prosecutorial misconduct, nor have we alleged that anywhere in our brief on that issue.
Well, I mean, if it's not prosecutorial misconduct and defense counsel had an opportunity to review the video.
Let me just, maybe there's a disconnect here. The day before this video was shown, I believe it was the day before, defense counsel and the prosecution went through the video meticulously. There was a day taken off of the trial to do that, and the parties agreed what would come in and what would not come in. And they agreed that that information, it was actually a subject of a motion in limine, that information about pushing Michael Carrara, or Eric Durand's pretty long statement about pushing him, would not come in. And that information was determined that would not come in, despite that agreement and despite the fact that the judge had ruled that would not come in. That came in.
So it was a screw-up by the prosecutor at a
could very well be a screw-up by the prosecutor. And I mean, through, we had a long session with Mr. Bradle, myself, and ADA McCauley, Bill McCauley, and that wound up coming in. And the
judge
issue,
gave a curative instruction, however.
The judge gave a
and
curative.
you're not claiming that it was an inadequate curative instruction.
No.
The question, you say the mistrial should have been granted because it was a second screw-up, but it was a
Exactly.
very minimal one, wasn't it? It was
No.
only 20 seconds, and it was
Well,
about
20
the very same subject that the judge had just given him an adequate curative instruction about?
Well, we asked for the mistrial before the judge gave the curative instruction, but he gave the curative instruction. And then there was about another, this is a long statement that where Mr. Durand goes into.
But the jury had heard most of it.
A jury had heard, they had heard, there's about 20 seconds left. I don't know exactly where in this statement that it picked up on, but the jury heard a good portion of it. The curative instruction is given, and then they hear it again, and there's more. I mean, even at the end, he's talking about obviously he wouldn't like me because I pushed him, but he didn't see the wrong in throwing a baby like that. That was wrong for me to push him. So he's talking, that's at the tail end of the statement. So they're hearing that again after the judge had already given a curative instruction. And Commonwealth versus Gary said, okay, these are what you need to do. Yeah, a jury is presumed to follow a curative instruction, but here, these are the things. It has to be a prompt curative instruction, which is fine here, and the jury never hears this again. It never hears this again. Well, they did, and they heard the same subject matter about pushing it. They could have stopped this. Once that curative instruction was given, once the judge said, okay, I'm going to give a curative instruction, stop it. Don't play the tape again. Don't let them hear another 20 seconds of this. They had it in their power to stop them. They didn't. That's extremely prejudicial. And
As the jury was listening to this, was there a transcript that the jury had to follow it?
I don't believe so. I'm not 100% sure, but I don't.
Listening to this without a transcript? They're just purely their own listening to the tape as to
I believe that's correct, Your Honor. I can double check that, but I believe that was the situation. And they heard this again, and I just want to point.
And the length, I gather it was a 6-hour interview, I believe.
Yes.
What was the length of the amount that they heard?
How
much was redacted? Were they listening for basically 5.5 hours?
No, and the amount is set forth. The amount that they heard is set forth in the Commonwealth's brief on page 38 and 39, and it's It's certainly not hours. They weren't listening for hours because a very timely objection was raised by Mr. Bradel, but it certainly wasn't hours. But they did hear this, they did hear a pretty substantial, this isn't just one sentence. It's pretty substantial.
No, I know that they heard this whole paragraph there. My question is, what was the length of the entire?
Oh,
I mean, they're
that.
listening for how long to a tape recording of the defendant's statement?
There was a redaction in the statement, but it was fairly lengthy, but I'm not sure if it amounted to hours. I don't know if I have the exact time on that. I'd also just, I see my time is running short here, but I'd like to briefly just talk.
It's running out, but you have a sentence or two. Go ahead.
Okay, I just, well, very briefly, the issue of the victim fear here is very different. This isn't a situation where the prosecutor is using closing argument to respond to an allegation of victim fear. This is actually making a very, very strong statement in terms of the victim fear, which is very different. When you say something, for most 4-year-olds, the boogeyman is a figment of their imagination. In this case, there is a boogeyman. There was a boogeyman in the life of Brendan Kamara. He's the defendant in this case. That's using it not as a defensive way to show that he didn't have a loving relationship. That's using this as a sword to come after somebody and say and to use victim fear to paint this person as a boogeyman. That's completely improper under Sears and Qualls.
But I mean,
What's that?
it seems that there was evidence that the child feared him, correct? He had expressed that during the course of the trial.
That's correct.
And so would that not be corroborative of the prior bad acts, that he indeed was seen doing stuff to a kid which a kid would make a kid afraid of an adult?
I think if it were phrased differently, possibly, if that were phrased as some sort of rebuttal to something, but it wasn't. He was trying to, what we're doing here, and this court has said in Sears and Qualls before, that when you start using victim fear as a sword in this particular sense, you run into problems, especially you allow the jury to put themselves into and switch the two, the defendant and the victim. And that's a big problem here when you're determining, especially when you're determining not only guilt, but you're determining the levels of guilt in terms of whether you're finding extreme atrocity or cruelty. And that could be very misleading and causes that particular problem. Again, it wasn't, oh, they're saying he didn't have a loving relationship, but he did have, they're saying he had a loving relationship, but we know he didn't. That's not it. He's using this and saying, this is the boogeyman. Picture the fear. I want you to consider the fear that Brendan Kamara felt. Those are different issues. Okay. If I just may, one point, Your Honor, just I didn't address before, is that when this court, in Judge Botsford's prior decision, going back to the previous argument, when Judge Botsford's prior decision, she ruled that when the jury heard about a slap to Laura Bowden, that slap, not a long paragraph about pushing Michael, but that slap was prejudicial error warranting reversal. And I would submit that if that were the case in that instance, with Laura Bowden and a single slap, then it certainly would be in this particular case.
Okay, thank you.
Thank you, Your Honor.
May it please the court, Tara Blackman for the Commonwealth. The first issue I'm going to address is Dr. Phillips' email to the previous ADA working on the case and why Judge Kane acted well within his discretion in finding that the defense counsel should not cross-examine him on that specific email.
It not just limited to that specific email? It wasn't also as to the termination of the medical examiner?
That's correct, Your Honor.
So it wasn't really limited just to the email?
Well, it was limited to, correct, it was limited to the termination also. The Judge Kane said he didn't want this to become a case of Dr. Phillip versus the OCME.
I understand
He
that.
wanted it to pertain
Was Bull Cumming decided already?
I believe Bull Cumming had been decided already, but I think that as Justice Cordy pointed out, that case is dealing with a hypothetical situation in which the court is saying, look, these are all the areas that he potentially could have been cross-examined about. But here, the judge knew, Judge King was aware at the time what the termination had to do with. And I just want to clarify something. And I know if this court looks at the opinions dealing with the civil case, the First Circuit issue, which I urge the court to do, none of the reasons why Dr. Phillip was terminated from the OCME had anything to do with his abilities in terms of his autopsy abilities or his reporting abilities. The death certificate issue, just like the email issue, had to do with interoffice politics. And that was what Judge Kane was limiting. He was saying you cannot question you should not be able to question Dr. Phillip about a hyperbolic expression of exasperation with a fellow colleague because that has nothing to do with the relevant issues at hand, which was really Dr. Phillip's ability to conduct the autopsy in this case and his ability to report on it and his ability to do so in a timely manner. And defense counsel had the opportunity to cross-examine on that, and he did ask him about whether or not he was able to get the file in a timely manner and whether or not he was able to do his report. Diminishment of memory, he had the opportunity to cross-examine about that. Judge Kane made that repeatedly clear, time and time again, how expansive cross-examination can be. The Confrontation Clause right certainly doesn't give defense counsel free rein to ask about anything, and it is a matter of discretion for the trial judge. So I think in this case, it's clear Judge Kane acted well within his discretion in limiting that cross-examination. Going on to the second issue that my brother raises with respect to the error in hearing the videotape, that erroneous, the narrative. Again, I want to clarify something. It had been agreed on before, certainly, and this was an error that it
There were
came in.
3 errors made, right? I mean, there were 3 ways in which the videotape was supposed to have been corrected and it was not done.
I believe there was 2.
Other fleeting reference to Michael?
That was the second.
No, that was, first was the entire, you're saying.
Oh, I'm saying the entire narrative was one. I apologize, Your Honor. Yes.
Okay,
So
well.
yes. So correct. And there had been a discussion about the redactions, and it had been made clear that the narratives about, and there were several narratives throughout. I want to explain throughout the videotape. So this is the only narrative that the jury heard. They should not have heard it, absolutely. But there had been a previous discussion, I believe it was the Friday before. And the Friday before, it was made very clear the parties discussed what exactly was to be redacted. And the prosecutor said, I'm even willing to lend, if the defense counsel has a problem viewing this tape, we're happy to lend them our computer
After the
to
redaction?
view it. This was after it was discussed what the redactions
No, but
were.
not after the redaction was made. Did the defense attorney have an opportunity to look at the redacted version?
Well, that's what the prosecutor said that he was going to do over the weekend, and that was, Judge Kane said that should be done before the weekend, before the video was shown to the jury. So defense counsel was supposed to review that before it went in. And then this whole thing happens where...
Prosecutor should have 2.
Yes, absolutely, yes. Both parties were
Saying
supposed
this was
to.
a mutual screw-up.
Exactly. I'm saying, yes, exactly. I'm saying it was a mutual screw-up, and there was even a discussion about that after that screw-up happened, that Monday after the jury heard that, and the prosecutor noted, look, defense counsel also looked at this. Clearly, this wasn't intentional. I had him look at it after. And defense counsel said, well, it was the prosecutor's responsibility to take this out, and Judge Kane said, no, it was both of your responsibilities, but I gave the curative instruction. Judge Kane did exactly what he was supposed to do.
Well, wouldn't you think after you get the, and he's not challenging the adequacy of that in a curative instruction.
Correct, Your Honor.
But that after that the prosecutor should have maybe taken a look to see what he was going to play next?
I think, I don't exactly know why it wasn't stopped at that point, but I will say that the remainder of it was another 20 seconds of what the jury had already heard, and it wasn't much more of, I pushed Michael. It was
Know
really...
what it was. Is there a...
Because
Do we know this?
Because it was only the end of it, and the end of it, we have the entire narrative, and it's the defendant even
But we don't
states-
even, do we know where was the cutoff? I was having trouble figuring out which...
we don't know exactly. We just know that it's talked about by the parties, that it's just the ending of it, so the last about 20 seconds. So, and we can see from the narrative, which is set forth in the Commonwealth's brief, page 38 to 39, the narrative is really, the ending of the narrative is really just, Michael was mad at me. So this was really just, not much more of, I pushed Michael. That was already said in the first part of it. And again, the judge gave a curative instruction, not just disregard what you just heard, but disregard this whole interaction that you're hearing, you heard about this defendant's interaction with Michael. So they've already been made very clear to the jurors, do not listen to this whole interaction, do not consider it. And jurors are presumed to follow the judge's instructions.
But what do we make about the case cited by counsel saying that when it's one thing if it happens once, it's really another thing if it happens again? And it did happen again.
Well, I think the standard is that, look, this is how to cure it, and then we don't want to hear it again. And I would say that there would be a real problem here if one of those other narratives where the defendant separately again talking about pushing Michael was heard by the jury. Then we might have an issue. But we don't hear. Really, all they're hearing the remainder of is Michael was mad at me, which had just already been said, and the judge has made it very clear, disregard this whole interaction you're hearing. Also, I have not been able to find one case where where inadmissible evidence came in, and this court said that in this type of circumstance it was a basis for a mistrial. Really, the court has always found that a curative instruction is enough to cure these type of issues. The issues where a mistrial is appropriate is, say, where a defendant hasn't been given exculpatory evidence. But I haven't found any case in Massachusetts where the court has said some type of inadmissible evidence of this type has resulted or is appropriate for a granting of a mistrial. And also, I want this court to consider the substance of this narrative and why it really wouldn't have really prejudiced the defendant very much.
I know that, but you're saying, well, because it shows he was an equal opportunity offender as to the twins.
Well, not just that, but I think that given all of the other evidence of the defendant's teasing and torturing of Brendan, I think that's what prejudiced the defendant in this case, and that was clearly admissible evidence because it went to the defendant's motive and everything else for what he did to Brendan.
Defendant obviously tactically did not want to have evidence of his pursued, his whatever you want to call it, mistreatment of the other brother before the jury.
I would say that...
And the judge agreed that that would be prejudicial.
Yes, the judge agreed that would be prejudicial. I agree. And I'm
saying, well, it doesn't matter anyway because it really wasn't prejudicial.
I'm saying that in light of all of the other evidence, the single narrative that the jury was told to disregard, I'm saying that this could not have prejudiced the defendant in light of everything else. I'm saying that if there was repeated evidence and discussion of the defendant's abuse of Michael, perhaps, but where this is a single incident and the defendant saying it was because he threw my 10-month-old baby to the ground.
Basically saying we should make a different determination as to the prejudicial nature of this than the trial court judge did.
I'm not.
The trial court judge basically said it would be prejudicial, and that's why the trial court judge said you shouldn't.
And I'm saying that in light of all the other evidence now that was already produced at trial. So we have all the other evidence that was produced at trial. And I would say also, again, that there would be a problem if that curative instruction had not been given. I'm just saying that the curative instruction was given, so we have to look at everything in light of the fact that that curative instruction was given, the substance of the evidence itself. So we look at everything cumulatively, and when we do so, I think comes to the conclusion that this certainly would not have warranted a mistrial.
If I can turn you briefly to an argument made in the briefs but not discussed this morning, is the closing argument reference to the toy shark.
Yes, sir.
Was there an objection at trial to that part of the closing?
No, there wasn't, Your Honor. And the reason for that is very clear. It didn't warrant an objection. And the reason it didn't warrant an objection was because it had to do with the defendant's October 20th statements, not the 21st statements that were suppressed.
Well, it would be. Did he say that he didn't?
He said that he didn't throw anything, and the evidence was that he did, and that was all that.
I know, but the next day he did speak of it. So it's a bit misleading to say he didn't say anything about it when in fact he did say something about it, albeit the next day, and that was barred by the judge.
I think that would have been misleading if the prosecutor hadn't clarified during the closing argument that he was talking about the first interview. So really, it's what it is defendant doesn't say anything during that first interview about he denies having thrown anything.
He denies having thrown something, and then he also, right after that interview, tells someone else not to remember that.
Exactly. And I think that is why it is actually not only proper, but it was essential for the prosecutor to point it out, because the defendant contradicted himself that night when he called. The evidence was that the defendant was lying. He was not credible because he told Patty that evening, after he denied throwing anything at Brendan. He calls Patty that evening and says, "Don't tell the police that I threw that toy shark at Brendan."
But the closing argument really references the statements that he made to police.
Correct. During the October 20th interview.
No, it's just on the, you'll recall in the course of his statements, things that were asked, he told the police they asked him, did you ever throw anything at the boy when he was in the corner? Sorry, that day. Did you ever throw anything? No, we know that's not true. He threw the shark. That hit him in the mouth.
On the
So-
corner that day. I believe it's clear.
It was the day of the events, the
I
day that he
believe-
stuck with the kids.
From my understanding, when I was reading from the entire context of the argument, it was clear. It appeared clear to me that he was talking about the defendant's interview that day. So I think that, and even when the defense counsel did not object to it, but even when he filed his motion 25B motion for a new trial at the sentencing hearing, he brought that up, and the prosecutor explained. I was arguing that it was the statements that he made that day, and how the evidence contradicted that. And I think I think he was entitled to do that. In no point during the closing argument did the prosecutor say, look, there's that discussion and the defendant denied it on October 21st. That statement was never mentioned.
If I can turn you to an argument, again, not made by anybody, but we have obligations under 33E.
Of course.
Evidence of extreme atrocity or cruelty.
Yes.
What was it in this case?
I would say it was first of all, you have the squeezing or punching of Brendan, I'm sorry, in the bathroom. It's going on for, it's just the injuries themselves, they were so severe that his small intestine was separated from his stomach, and his his pancreas, and also you have testimony from the experts that he would have been in severe pain. He would not have been able to live long. He would not, after that, when the minutes later, when the paramedics got there, he wasn't breathing. He was blue. So I think that the severity of the injuries and the fact that there was no injuries on him based on all the testimony before this incident, and this took extreme amount of force. And I think both experts, Dr. Goldberg testified to it, Dr. Phillip testified to it, that this would have taken an extreme amount of force. We're talking.
Say that, but if he had shot a bullet into his head, that would have been an extreme amount of force, but we wouldn't say that's extreme atrocity or cruelty.
Correct. I would say that just the amount that the pressure he would have had to be using with his bare hands. Also, there was the evidence that there was blood on the defendant's
Which Kunin
hands.
factor do you say that bears on? I mean, it's usually an unnecessarily severe amount of force, but here, there apparently was, or arguably, at least the jury believed there was a punch in the stomach so severe as to have split it.
Yes.
Evidence of continual punching of anything beyond? I mean, certainly we have cases in which the person is punched and then later kicked around and the kicking around, but on this one, as far as I can tell, it was a single fatal punch and the child died, became unconscious very quickly and died shortly thereafter.
I don't know that it was a single fatal punch. There were also other injuries to his body. I believe there's 9 injuries to his all over his body. So I would say that this just isn't I would say that there's more. There's some type of squeezing. There's other injuries to his body. There's been injuries to his back, his front, that is one of the injuries. That is the cause of death, the separation from his stomach and his small intestine.
Were the injuries to his mouth done by the shark?
That was the theory. The injuries were done by the shark. Yes.
And so that would not go into the extreme atrocity or cruelty analysis?
I think that was for the jury's determination. So I think that we're relying on the extreme atrocity and cruelty for the injuries to his body.
Was the toy shark offered into evidence? Was there any description of it? Was it inflatable? What kind of toy shark was this?
I believe there was. I don't remember if it was admitted into evidence. I think it was a rubber toy shark. There was some reference to it being a rubber toy shark.
Is there a photo of it anywhere in the record?
I don't know if it was a photo, if it was admitted to evidence. I don't believe so. But I can check on that and certainly let the court know. So,
We'll find it if it's there. Thank you.
is there any other questions from Your Honor, from the panel?
Okay, thank you.
That's the rest of my brief. Thank you.